Hello everyone, welcome back to Bajirao IAS Academy. So the prelims 2024 exam has been approaching fast and we have been discussing the current affairs for UPSC Prelims 2024. And in this session also I have few more important current affairs from the polity section. So we'll try to discuss them in a much comprehensive manner because I've given all important current affairs. I've been covering all important current affairs which are very relevant for the exam. So therefore we'll start this discussion by first understanding about this Law Commission of India. Now, Law Commission of India is very often in news, and we also very often read about this Law Commission of India and its recommendations and everything. Now, first and foremost, understand the Law Commission of India is a non-statutory body. Now, what is a non-statutory body? So, it is a body which is set up through an executive order. It does not have any statutory backing. Okay, so it does not have no statutory backing. So that body is known as the non-statutory body. Now, this particular Law Commission of India is constituted by the Government of India from time to time. And apart from that, it is a non-statutory body and also an advisory body under Ministry of Law and Justice. And if you look at the composition of the Law Commission of India, so it consists of a full-time chairperson. So it has a full-time chairperson, and apart from the chairperson, it also has 4 full-time members. And these 4 full-time members including the member secretary as well. And apart from the 4 full-time members and a full-time chairman, so this Law Commission of India also comprises the Secretary, Department of Legal Affairs as ex officio member, and then Secretary, Legislative Department as ex officio member, and then not more than 5 part-time members. Now, all these members actually part of the Law Commission of India, and they actually make recommendation or provide advices on India's laws. Now, the current Law Commission of India is 22nd Law Commission, and that was approved in the year 2020. So the current Law Commission is set up for a period of 3 years, and which was extended up to August 2024. Now, briefly understand the historical background of this Law Commission of India. This Law Commission of India was first established during the British era or during the British Raj in 1834 by Charter Act of 1833. Now, Charter Act of 1833 has provided for the establishment of the Law Commission of India in the year 1834, and it was chaired by Lord Macaulay. And in fact, Lord Macaulay is also very well known for his education reforms in British India. So first independent Law Commission was constituted or created in the year 1955 for a period of 3 years again, and it was headed by MC Settleward, also the first Attorney General of India. And this is the brief background about the Law Commission of India. Now we'll understand the functions of the Law Commission of India. It performs the following functions. Now, first and foremost, it reviews the existing obsolete laws. Now, obsolete laws in the sense that they are outdated laws. So therefore the Law Commission of India is actually tasked with reviewing these outdated laws. And apart from that, it will also examine the socio-economic legislation which is impacting the poor, and also ensure the judicial administration is responsive to the current demands. So this is one such function of the Law Commission of India. And apart from that, the Law Commission of India also examines the existing laws in light of the state policy directives, such as the directive principles of state policy. And apart from examining and reviewing those laws, it also provides suggestions for the improvement of those laws and bringing in new reforms in the legislations as well. So the review also focuses on promoting gender equality and at the same time proposing new amendments to the existing laws. So the review also aims to simplify the central acts and at the same time remove any anomalies in those legislations. However, understand the Law Commission recommendations are purely advisory in nature. They are not mandatory. Those recommendations or advices are not mandatory on the part of the government. Okay, so next we'll briefly understand about the Central Bureau of Investigation as well, because Central Bureau of Investigation is also very often in news. So we'll try and understand few specific things about the CBI. Now, it is a premier non-statutory investigation or investigative agency. Now, understand the Law Commission of India is non-statutory body and CBI is also a non-statutory body, but it is a premier non-statutory investigative agency of India. Now, when it was established in 1963 based on the recommendations of Santanam Committee on the Prevention of Corruption. So please remember this. The CBI was established first in 1973 based on the recommendations of Santanam Committee on Prevention of Corruption. Secondly, so from where the CBI actually derive its powers from? So it derives its powers from the Delhi Special Police Establishment Act. And apart from that, CBI also provides assistance to the Central Vigilance Commission and at the same time Lokpal as well. So because please understand the Central Vigilance Commission or Lokpal, that they were created primarily to check corruption. Now, in fact, the Central Bureau of Investigation also investigate the corruption related cases. So therefore, CBI provide assistance to both Central Vigilance Commission and at the same time the Lokpal. So Lokpal was created, it is an anti-corruption agency that was created at the central level, and Lokayukta was created at the state level. And it is also a nodal police agency in India which coordinates its investigations on behalf of the Interpol member countries at the international level. Now, understand, Interpol is an agency at the international level and which deals with the wide variety of cases, criminal cases and civil cases. So therefore, the Interpol, the coordinating agency, or in India, the nodal police agency to coordinate investigations on behalf of Interpol member countries is CBI. Now, who controls the Central Bureau of Investigation? It is also very important for us to understand this. So, the Ministry of Personnel, Public Grievances and Pensions. And this was the ministry which operates the Central Bureau of Investigation, or which controls the Central Bureau of Investigation. Also understand, the Central Bureau of Investigation is not a statutory body and it operates under the jurisdiction of Ministry of Personnel, Public Grievances and Pensions. But understand, for investigating offences under the Prevention of Corruption Act, it actually vests superintendence to the Central Vigilance Commission. Now, what are the basic functions of the Central Bureau of Investigation? So it performs the following functions. So initially it was established to investigate corruption related cases in government departments, but over a period of time, what happened, the jurisdiction of this particular Central Bureau of Investigation has further expanded to cover a wide range of cases. So those wide range of cases including the economic offences, cyber crimes, organized crimes and all other special crimes. So all of these crimes can be investigated by the Central Bureau of Investigation. Now, how the director of the Central Bureau of Investigation is being appointed? So he is responsible for the overall administration of the CBI and he is appointed by the central government based on the recommendations of a three-member committee, a three-member appointment committee. Now, this three-member appointment committee again comprises of Prime Minister, and Prime Minister is the chairperson of this particular committee, and leader of opposition in the Lok Sabha, and Chief Justice of India or Supreme Court judge who is nominated by the Chief Justice of India. And this committee recommends the chairman of the Central Bureau of Investigation, and based on the recommendations of this particular committee, the central government appoints the director of the Central Bureau of Investigation. So please remember this committee. And if there is no recognized leader of opposition in the Lok Sabha, then the leader of the single largest party will be included in this selection committee or in the appointment for a committee for the appointment of the Central Bureau of Investigation's director. Now, apart from that, with respect to Central Bureau of Investigation, we very often coming across the term called consent or general consent. Okay, so general consent in the sense that now Central Bureau of Investigation cannot investigate any case on its own without having this general consent from any state. Now, I'll tell you one example that recently the West Bengal government has withdrawn general consent for CBI. Now, withdrawing general consent for the CBI actually means that CBI cannot investigate any case in West Bengal state unless it is directly ordered by the state high court or the Supreme Court. So therefore, general consent is actually issued by the respective states, indicating their willingness to allow CBI to investigate different cases in those states. However, recently CBI is a bone of contention between the center and states, because states are very often saying that the central government using CBI as an agency against the state governments, and because of that reason we have seen recently series of states withdrawing their general consent for the Central Bureau of Investigation. A petition was also filed in the Supreme Court with respect to the Central Bureau of Investigation and its over activism. And so next we'll briefly understand about the National Commission for Scheduled Caste and understand, unlike the Central Bureau of Investigation and Law Commission of India, this National Commission for Scheduled Caste is a constitutional body, because the constitution directly has a provision with respect to the National Commission for Backward Classes. Okay, so therefore we can say that it is a constitutional body under the jurisdiction of Ministry of Social Justice and Empowerment. Now here you have to understand this very clearly without any confusion. The National Commission for Scheduled Caste is a constitutional body first, and it operates under the jurisdiction of Ministry of Social Justice and Empowerment, Government of India. Now, what was the purpose of setting up this National Commission for Scheduled Caste? So it actually provides safeguards against the exploitation of scheduled caste Anglo-Indian communities. And at the same time, along with providing safeguards to these marginalized sections of the society, it will also promote and protect their social, educational, economic and cultural interests as well. Now, what are the constitutional articles which are specifically dealing with the National Commission for Scheduled Caste? So Article 338 actually contains provisions with respect to the National Commission for Scheduled Caste. So please remember this article, Article 338. Now, apart from that, Article 338A also deals with the National Commission for Scheduled Tribes, and there is another article within Article 338, that is Article 338B. So this Article 338B actually deals with the National Commission for Backward Classes, and recently the National Commission for Backward Classes was given a constitutional status under Article 102 of the Constitution. And because of that reason, it is in news as well. So please remember these articles, Article 338 and Article 338A, that deals with the National Commission for Scheduled Caste, and Article 338B that deals with the National Commission for Backward Classes. The 89th Amendment Act 2003. So Article 338 was amended, and that has introduced Article 338A. Okay, so 89th Constitutional Amendment Act that was amended in 2003. So this has amended Article 338 and provided for Article 338A. Now earlier we have only National Commission for Scheduled Caste, so that looks after the safeguarding the interests of both scheduled castes and scheduled tribes. Now with the amendment, a separate National Commission for Scheduled Tribes was established. National Commission for Scheduled Tribes was also established through this 89th Constitutional Amendment Act. So that has introduced Article 338A. Now, the erstwhile or earlier National Commission for Scheduled Castes, Scheduled Tribes was replaced by two separate commissions, National Commission for Scheduled Caste and National Commission for Scheduled Tribes from 2004. And apart from that, we have also understood that Article 338B provides for setting up National Commission for Backward Classes, and in fact Article 102nd Constitutional Amendment Act, 102nd Constitutional Amendment Act provided for a separate article, that is Article 338B, and this 338B has established the National Commission for Backward Classes for safeguarding the interests and at the same time promoting and protecting the rights of the other backward classes. The National Commission for Backward Classes was established. And in fact, the first Commission for Scheduled Caste and Scheduled Tribes was constituted in August 1978. And it functions from its headquarters in Delhi, and it consists of a chairman, a vice chairman and 3 other members. So this is how the National Commission for Scheduled Castes is constituted: 1 chairman, 1 vice chairman, along with that 3 other members. Now, the central and state governments are required to consult National Commission for Scheduled Caste on all policy matters which are affecting the scheduled caste. For example, imagine that the central government or state government are making any policies, and if they are making any policies, they must consult any policies with respect to the scheduled caste, because those policies certainly impact the interests of the scheduled caste. Hence, before making any such policies, they must consult with the National Commission for Scheduled Castes so that it can make necessary amendments or it can suggest necessary recommendations to those policies which are being framed by the central and state governments. And the next important article is with respect to Digital Publisher Content Grievance Council. And this Digital Publisher Content Grievance Council was recently established. Okay, so in recent times we have seen a flooding of OTT content, a flooding of new OTT platforms, and those platforms have also been producing a wide variety of online content. So therefore, this Digital Publisher Content Grievances Council, so that is DPCGC, recently recommended a punitive action on OTT platform invoking the Information Technology Rules 2021. Now we'll briefly understand what exactly is this Digital Publisher Content Grievance Council, and this is not a statutory body, rather it is an independent self-regulatory body for online curated content providers. Now what is a OTT platform? OTT platform is a platform which provides over-the-top services. For example, Netflix is an OTT platform, Amazon Prime is an OTT platform. So those platform actually provides online curated content. So they are online curated content providers. Now this Digital Publisher Content Grievance Council actually an independent self-regulatory body for this online curated content providers, and this was set up under the aegis of Internet and Mobile Association of India. Now remember, these things are very often asked by the UPSC, so therefore these are very, very important things, right? So it was set up under the aegis of the Internet and Mobile Association of India. Which one? So that this Digital Publisher Content Grievance Council, so that was established under the aegis of Internet and Mobile Association of India. This Digital Publisher Content Grievance Council has been recognized and registered by the Ministry of Information and Broadcasting. Okay, so this particular ministry has has taken up the task of recognizing this Digital Publisher Content Grievances Council as a level 2 self-regulatory body for publishing online curated content. So under the Information Technology Intermediary Guidelines and Digital Media Ethics Code of 2021. So in 2021 also the government framed this particular IT rules. and those IT rules were also very important, and they are also talking about the safe harbor mechanism. Okay, safe harbor, a mechanism of these social media platforms, and it also talks about the online information or fact checking unit. So which one the fact checking unit here? The Press Information Bureau was established as a fact checking unit by the government under this IT rules of 2021, right? So what exactly is this safe harbor which is being extended to the social media platforms? So safe harbor actually means that the third party information, so the social media websites or intermediary platforms are not accountable for the third party information which is being posted on those intermediaries. For example, either Twitter, which is now known as X, or Facebook. So if any user posted any sensitive information on these social media websites, then the intermediary platforms such as those social media platforms are actually not responsible or not accountable to those such content. So therefore that is known as safe harbor mechanism. And in fact the IT rules have also provided for withdrawing the safe harbor provision for these intermediaries if they don't remove such a sensitive, misguiding and false information from those websites. Now after that, the Digital Publishers Content Grievance Council has an online curated content publishers council. Okay, so it also has one more council, so that council is known as Online Curated Content Publishers Council, and this council is composed of publishers of all online curated content, and publishers of all online curated content will become the members of this particular Online Curated Content Publishers Council, and an independent grievance redressal board. Okay, so it also consists of an independent grievance redressal board. For example, if there are any grievances against this online curated content, then the grievance redressal board would redress those grievances. Okay, so this particular grievance redressal board actually consisting of a chairperson and 6 other members. And this grievance redressal board will be chaired by a retired Supreme Court or High Court judge, right? So it is chaired by a retired Supreme Court or a High Court judge, and at the same time all other remaining 6 members are actually eminent persons from different fields. So fields include their eminent persons from media, entertainment industry, and even experts from various other fields including child rights, minority rights, and even the media law as well. Now, what are the functions which are being performed by this grievance redressal board? So the grievance redressal board, understand this, that the grievance redressal board actually consisting of chairperson and 6 other members. Now what are the basic functions that are being performed by this grievance redressal board? So it performs the following functions. So it will oversee and ensure the alignment and adherence to the code of ethics by the Online Curated Content Providers Council members. Secondly, it will also provide guidance to entities on the code of ethics. So what should be the code of ethics? So every guideline or guidance would be provided by this particular body. And after that, it will also redress or address grievances that have not been resolved by the publisher within the 15 days. And lastly, it also hears grievances appeals which are being filed by the complainants. So these are the basic functions which are being performed by the grievance redressal bodies. And next we have the Enforcement Directorate, and this Enforcement Directorate is also very often in use, and therefore we can expect a question on this Enforcement Directorate as well. Now, so when was this Enforcement Directorate was established? It was established in the year 1956. Please remember this, it was established in 1956 as an enforcement unit. So its initial name was Enforcement Unit, and it was established in the year 1956. Now it comes under a ministry, or Ministry of Finance under Department of the Economic Affairs. So therefore the Enforcement Directorate actually comes under the Department of Economic Affairs. However, In 1957, so this enforcement unit were renamed as the Enforcement Directorate. So earlier it was known as Enforcement Unit. In 1956, this was the year in which so this Enforcement Directorate was established. But in 1957, this unit was renamed as Enforcement Directorate. Now, the administrative control of this Enforcement Directorate, that means who controls the Enforcement Directorate. This is also a very important thing that we must understand here. Now, this Enforcement Directorate is actually under the administrative control of the Department of Revenue. So that is under the Ministry of Finance. So please understand, both the Department of Revenue and Department of Economic Affairs are under the Ministry of Finance. So therefore, the Enforcement Directorate under the administrative control of Department of Revenue, which is under Ministry of Finance. Now, what are the basic functions of this Enforcement Directorate? So Enforcement Directorate actually performs the following important functions. So Enforcement Directorate is actually responsible for the enforcement of Foreign Exchange Management Act of 1999, right? So this, its first and foremost function of Enforcement Directorate is that it enforces the FEMA Act of 1999 and certain other provisions under the Prevention of Money Laundering Act of 2002, right? So it is being tasked with enforcing the provisions of both Prevention of Money Laundering Act and at the same time the Foreign Exchange Management Act of 1999. And apart from that, it also performs few other functions. So what are those functions? The Enforcement Directorate actually has the power to attach the asset of the culprit who found guilty of the violation of FEMA Act. For example, so if any person who violates the provisions under the Foreign Exchange Management Act of 1999, so what Enforcement Directorate will do? Enforcement Directorate actually attach the assets or confiscate the asset of an individual who is found guilty of violating this Foreign Exchange Management Act of 1999. And apart from that, another important function which is being performed by the Enforcement Directorate is it also empowered to undertake search, seizure, arrest and protection or prosecution, and even taking action, survey. So therefore, the Enforcement Directorate has actually given all these responsibilities, all these powers under those various legislations, especially against the offences which are being committed under the Prevention of Money Laundering Act. Now we have understood the appointment process of the Central Bureau of Investigation. Now how Central Bureau of Investigation chairperson or director was appointed? So he was appointed by the central government but based on the recommendations of a selection committee. Now the selection committee consists of Prime Minister as the chairman of the committee, plus leader of opposition in the Lok Sabha and the Chief Justice of India or any other judge who is nominated by the Chief Justice of India. So this was the committee so which recommend a name for the central government for the appointment as a directorate of the Central Bureau of Investigation. So this is what we have understood. Now we try to understand how the Director of Enforcement Directorate is actually appointed. The Enforcement Directorate Director is appointed by the central government on the recommendations of a committee. Now again appointed by the central government and again it is based on the recommendations of a committee. Now what was this committee and what are these who are the members of this committee? We'll understand very briefly. Now this particular committee is chaired by the Central Vigilance Commissioner. Okay, so it is headed by or chaired by the Central Vigilance Commissioner and the members who are comprising of the Vigilance Commissioners and apart from them Home Secretary, Secretary of Department of Personal Training and Revenue Secretary. So these are actually the members of a committee which actually recommend a name for the appointment as the Enforcement Directorate Director. Okay, so next a very important current affairs is about the Central Consumer Protection Authority. Now this is also very important because UPSC questions are very often modeled on these lines. Now what exactly is the Central Consumer Protection Authority? So this Central Consumer Protection Authority was established in 2020 and again it is a statutory body. Now statutory body, I'm repeating again, it is established through an act of Parliament. Now, the Central Consumer Protection Authority was established through the Consumer Protection Act of 2019. The Consumer Protection Act 2019 has provided for the establishment of the Central Consumer Protection Authority. So this was established in the year 2020 to protect the consumer interests. Now, who are the consumers? For example, you being purchasing any product from the e-commerce sites, from any retail store. Now, you will be the consumer. And what if you get a defected product? Now this Central Consumer Protection Authority will step in, and then it will protect your interest as a consumer. Okay, so that is the overall responsibility of this Central Consumer Protection Authority, and it is a statutory body, and that was created through the Consumer Protection Act of 2019, and it functions under the Ministry of Consumer Affairs, Food and Public Distribution. Now don't confuse with respect to these ministries. So it was established through the Ministry of Consumer Affairs, Food and Public Distribution, right? So it functions under this particular ministry. Now, in this context, we'll briefly understand what exactly is the objective of Central Consumer Protection Authority. Now, what is its objective? Now, the basic objective of Central Consumer Protection Authority is to regulate the matters which are relating to the violation of consumer rights. Now, a person A getting a defective product from the e-commerce site, from any other retail store, then that amounts to the violation of consumer rights. And in order to protect the rights of consumers, the Central Consumer Protection Authority or State Consumer Protection Authority are being established to take a penal action against those entities which are selling these defective products, and at the same time they will also protect and enforce the rights of consumers as a class. Now, what is the composition of the Central Consumer Protection Authority, right? So it consists of a chief commissioner as a head and 2 other commissioners as members. The Central Consumer Protection Authority actually having a chief commissioner as a head and 2 other commissioners as members. So total 3 members, the Central Consumer Protection Authority. Now this chief commissioner and 2 other commissioners are actually appointed by the central government. Now, what are the powers and functions of the Central Consumer Protection Authority? Now, understand this Central Consumer Protection Authority conduct investigations, right? So, of course, it conduct investigation if it feels that the consumer rights are being violated, then it conduct investigations into violation of consumer rights, and at the same time institute complaints either on suo motu in the sense that so it can take up complaints on its own without receiving any complaint from any consumer. The Central Consumer Protection Authority can take complaints on its own, and this power is known as suo motu power, or any complaint received or on the directions from the central government. And apart from that, it can order recall of unsafe foods and services. So these are some powers and functions of the Central Consumer Protection Authority. And apart from that, there are also other major functions that are being performed. So it can do order discontinuation of unfair trade practices. For example, any entity which has been practicing these unfair trade practices, now what it will do, so it can result in order discontinuation, and even any entity coming up with misleading advertisements, it can impose penalties of up to 10 lakh. Okay, so after that, it can file complaints or even intervene in any proceedings before district or state or the national commission in respect of any allegations or violation of consumer rights or unfair trade practices. Now please remember that UPSC has been very often asking these things, so therefore it is very important that you pay minute attention to these statements, because UPSC has been directly giving these statements in the questions. And apart from that, it could also recommend adoption of international covenants and best international practices on consumer rights. because there are a lot of international conventions, rules, regulations, and internationally best practices. So though they are aimed at protecting the consumer rights, so therefore it could also recommend adoption of the international covenants, and then it could also undertake, promote awareness and research in the field of the consumer rights. And then it also encourages the non-governmental organizations which are engaged in protection of the consumer rights. Okay, so not just non-governmental organizations but also the other institutions which actually working in the field of consumer rights to cooperate and work with the consumer protection agencies. So these are some basic responsibilities and the functions of the Central Consumer Protection Authority. Now the next, Central Information Commission. So this is also very important. See, understand that UPSC every year asking about these agencies also. So these agencies are also in news regularly. So because of that reason, it is important for us to discuss these organizations as well in a bit detailed manner. Now, Central Information Commission. Now again, like a Central Consumer Protection Authority, this Central Information Commission is also a statutory body because it was established through a law passed by the Parliament. So therefore it is a statutory body constituted under section 12 of the Right to Information Act of 2005. So this Right to Information Act 2005 section 12 has been provided for the establishment of the Central Information Commission. Now what is the role and responsibility for, or what is the objective of the Central Information Commission? So the basic objective is to ensure a smoother and greater access to information envisaged under the RTI Act to Indian citizens through a citizen-centric approach. Now if I can tell you in a very simplest manner, so this is essentially empowering citizens through information. So that is the basic objective, empowering citizens through information, and that is the basic objective of the RTI Act or Central Information Commission. So therefore it is a citizen-centric approach. Now citizen-centric approach in the sense that it keeps citizens at the center of decision making or policy making. Now understand, this is not a constitutional body, but this is just a statutory body, not a constitutional body, because the Central Information Commission was nowhere mentioned in the constitution, and because of that reason it is not a constitutional body. However, it has a certain objectives. Now what are the basic objectives of the Central Information Commission? So the objectives include, it receives and then inquire into citizen complaints. For example, imagine that the Central Right to Information Act has provided for providing information to every citizen, or every citizen who sought information from the relevant government officer or government office. Now any government office has not provided information within the prescribed time period, then citizen can directly complain at the Central Information Commission. So therefore it receives and also inquire into citizens' complaint under section 18 of the RTI Act. So section 18 of the RTI Act has empowering the Central Information Commission to receive and inquire into citizen complaints. Secondly, it also receive and decide upon the second appeals from any citizen under section 19 of the RTI Act. The third objective, it exercises powers conferred on the Central Information Commission under RTI Act of 2005. And fourth is that to perform the duty of monitoring and reporting under section 25 of the RTI Act. So all four are basic objectives of establishing the Central Information Commission. Okay, now how the appointments are being made for the Central Information Commission. So how the appointments, right? So if you can understand the basic composition of the Central Information Commission, the Information Commission consisting of Chief Information Commissioner and not more than 10 information commissioners. Okay, so chief information commissioner and not more than 10 information commissioners. So therefore, so one chief information commissioner and 10 or less than 10 information commissioner, because it says that not more than 10 information commissioners. And chief information commissioner and the information commissioners are being appointed by the president. So please understand this, it is very, very important. So those are appointed by the president on the recommendation of a committee which is consisting of prime minister. So he is the chairperson of the committee, leader of opposition. Okay, so leader of opposition in the Lok Sabha. So he was known as LOP, leader of opposition in the Lok Sabha, and the prime minister. Okay, so and then union cabinet minister who is nominated by the prime minister. So this is how the chief information commissioner and 10 more information commissioners are being appointed based on this particular committee. So please remember this committee. So this committee consisting of prime minister, leader of opposition in the Lok Sabha, union cabinet minister who is nominated by the prime minister. Now, what was the term of office and reappointment of this particular chief information commissioner? So the members of Central Information Commission would serve the term as prescribed by the central government until they reach 65 years old. Okay, so the term of the members is actually decided by the central government, and chief information commissioner and other information commissioner or state information commissioners, state information commission chiefs and central information commission commissioners are not eligible for the reappointment. So they will not be reappointed once they served as a chiefs. Now the next very important thing that was in news in recent times was about the chief election commissioner and other election commissioners appointment, conditions of service, term of office act 2023. Right, so this legislation was recently passed by the Union Parliament, essentially to bring in more independence in the functioning, more independence in the appointment of the election commissioner and chief election commissioner. Because earlier, please understand, the chief election commissioner was appointed simply by the government. Okay, so the union executive can simply appoint the chief election commissioner and other election commissioners. Now there is no specific or separate setup for appointing both chief election commissioner and election commissioner. But on the other hand, under Article 324 of the Indian Constitution, the Election Commission of India is an independent and constitutional body, and therefore it is very important to protect independence of the election commission by insulating the appointments of the election commission from the executive. So for that particular purpose, the government has actually passed this particular legislation, and this legislation repeals or done away with the Election Commission, Conditions of Service of Election Commissioners and Transaction of Business Act 1991. And apart from that, this particular legislation also seeks to regulate the appointment, conditions of service, term of office of the chief election commissioner and other election commissioners. Now understand, since the chief election commissioner and other election commissioners are essentially appointed by the union executive, a few Association for Democratic Reforms filed a petition in the Supreme Court that even though Election Commission of India is a constitutional body, the appointment of the election commissioner, appointment of the chief election commissioner and other election commissioners are being done by the executive. So thereby it is deviating the independent functioning of the Election Commission of India. So for that particular purpose, what Supreme Court has done? Supreme Court has delivered a judgment. And as per the judgment, Supreme Court actually considered, Supreme Court has established a committee. Okay, so this particular committee which is being established by the Supreme Court, consisting of the Prime Minister, and then leader of opposition in the Lok Sabha, and the Chief Justice of India. And this committee will actually recommend a name to the president for the appointment as the Chief Election Commissioner of India. However, in response to the Supreme Court judgment, especially with respect to this particular committee, the Union Legislature has passed this legislation, this law, changing the composition of the committee which was mandated by the Supreme Court. Now we'll understand that in a very brief manner, very shortly. Now there are certain key provisions of this act. What are those key provisions? Because this has provided for the appointment of the Chief Election Commissioner and other election commissioners, and it will be done by the President, firstly. Secondly, it also prescribed for qualifications of the Chief Election Commissioner and other election commissioners as well. Because earlier legislations, there was no specific qualifications mentioned for Chief Election Commissioner and other election commissioners, but now this has been provided for the qualifications as well. So for being elected for the post of Chief Election Commissioner or Election Commissioner, so a person should be a person of integrity. So he should have a lot of integrity, and apart from that, he should also have or possess the knowledge and experience in the management and conducting of elections as well. And apart from that, he or she holding or have held a post which is equivalent to the rank of Secretary to the Government of India, and these are some of the qualifications which are being set for the appointment of election commissioners and the Chief Election Commissioners. Now also understand, earlier there was no such rules. Okay, so there were no such rules which have been actually indicating the qualifications, or which actually mentioning about the qualifications of Chief Election Commissioner plus the Election Commissioner for appointment of these posts. But this new legislation has actually provided for some qualifications, so that is the good thing, because anyone cannot be appointed as the Chief Election Commissioner and Election Commissioner, particularly because of these qualifications. Now, so this has also provided for a search committee. Now, search committee in the sense that this particular committee will actually look for the individuals with relevant qualifications and the integrity as well. Okay, so this search committee is headed by the Cabinet Secretary. So this search committee is headed by the Cabinet Secretary and including 2 members not below the rank of Secretary who are having knowledge and experience with respect to matters relating to elections. So essentially it is a 3-member search committee. This is a 3-member search committee. Okay, so I hope it is clear, and this committee will not recommend directly name. Rather, this committee will search for the individuals with relevant qualification and shortlist few candidates. For example, in this case we can take it has shortlisted 5 candidates, right? Now this 5 candidates names would go to the selection committee. Okay, so this is the next phase, and this selection committee shortlists one name and recommend the name to the president, and then ultimately he or she will be elected as or appointed as the Chief Election Commissioner. So this is how the procedure goes. Now again, this selection committee, it recommend names of the persons to be appointed as the Chief Election Commissioner and Election Commissioner to the president, and this particular selection committee consisting of Prime Minister, who is the chairperson of the committee, and leader of the opposition in the Lok Sabha, in the lower house or house of the people, that is Lok Sabha, and Union Cabinet Minister who is nominated by the Prime Minister as a member. So this is a 3-member selection committee. Now what differences you have been observing with the selection committee that is given here for the selection of Chief Election Commissioner and Election Commissioners, and the selection committee, so that was mandated by the Supreme Court. Okay, now only difference is that the 3rd member, Supreme Court has mentioned that Chief Justice of India would also be part of this particular selection committee. However, this legislation which is passed by the Union Executive has omitted the Chief Justice of India from this selection committee and included the Union Cabinet Minister who is nominated by the Prime Minister as a member. However, so one thing that you need to understand here, any vacancy or defect in the constitution of the selection committee won't make the appointment of the chief election commissioner and election commissioners invalid. For example, imagine that there is no leader of opposition in this particular selection committee, then ultimately Prime Minister and Union Cabinet Minister, they are from the same government, they can recommend any name to be appointed as the chief election commissioner plus election commissioner, and again that has been deviating the purpose and in fact undermining the independence of the election commission. So that is the criticism that was leveled against the Election Commission of India. And next we also have the Panchayat Development Index. So this is also important, so therefore we'll briefly try and understand what exactly is this Panchayat Development Index. Now this Panchayat Development Index is a computation score, so that is for granting or for grading panchayats across the country. So it is actually based on the development work so that is being carried by them towards achievement of the localized sustainable development goals. Now, panchayats are local self-governance institutions. They were established through the 73rd Constitutional Amendment. And in fact, Directive Principles of State Policy, Article 40, talking about the establishing the panchayats at the local level, and in fact it is one of the Gandhian principles in the Directive Principles of State Policy. Now in fact, so these panchayats actually play a most important role in the grassroots democracy, and at the same time we need to understand their potential in achieving the sustainable development goals. Okay, so reaching all the sustainable development goals by 2030. So therefore, in order to understand their performance in the achieving all these sustainable development goals by the year 2030, so we have devised this Panchayat Development Index. So essentially to understand their achievement of the localized sustainable development goals. And this Panchayat Development Index takes into account 9 essential themes. Now what are those themes? So 9 themes include poverty free and enhanced livelihoods in those villages, and healthy village which takes care of the health of all, universal health care, universal immunization of the people, and child friendly village where there is no child labor, there is no dropout rate, and all school age children are in school. Clean and green villages as well, which takes into account the environmental concerns, the environmental sustainability. Water sufficient villages, so that is in line with the Union government's Jal Jeevan mission, so which aimed to provide potable drinking water to all households by the year 2024. And then village with self-sufficient infrastructure in the sense that roads, schools, hospitals, libraries, everything, so they are having self-sufficient infrastructure. And socially just and socially secured village as well, village with good governance model, and woman friendly villages. And these are the 9 themes which are being adopted as part of the Panchayat Development Index. Now, so who prepares this Panchayat Development Index? So a committee which is being constituted by the Ministry of Panchayat Raj constitutes this particular this Panchayat Development Index. So please understand, a committee constituted by the Ministry of Panchayat Raj prepares this Panchayat Development Index, and this particular committee of the Ministry of Panchayat consisting members from different ministries and departments across union and state governments. Now what is the basic objective of this Panchayat Development Index? So it essentially assesses the ground realities. What exactly is the ground realities at the grassroots democracy, and what are the efforts which are being made by those panchayats to improve the livelihoods of the people and reduce the levels of poverty, and achieve universal health care and education for all those goals. So therefore efforts which are being made by the local governments in implementing various developmental programs in realizing these developmental targets and at the same time achieving the sustainable development goals as well. So what mechanism has been provided? So the Panchayat Development Index provides rankings for panchayats at different levels. So these levels include district level, block level, and the village level as well. So accordingly, it allocates grades as well. Grade A plus, so which has been which are the panchayats which have scored more than 90%. Grade A, so they have scored between 75 to 90%. Grade B, they have scored 60% to 75%. Grade C, 40% to 60%, and then grade D, less than 40%. So this is how the Panchayat Development Index actually grades different panchayats, and it is being prepared by a committee that is constituted by Ministry of Panchayat Raj. Now let's try to understand briefly about this guardian minister as well. So who is this guardian minister? So guardian minister is a cabinet level minister, so who is appointed by the state government. Now this guardian minister is also very often in news, and because of that reason we are giving this guardian minister. So this guardian minister is a cabinet level minister who is appointed by the state government, particularly to oversee the development of a specific district within a state. Okay, so that is the responsibility of the guardian minister. Now understand that imagine a state called Odisha. Now in this particular state there is a district called Ganjam district. Now this Ganjam district is very often known as the backward district, infrastructure backwardness, education backwardness, and backwardness in several other social factors. Okay, social indicators. Now the state government of Odisha will appoint a guardian minister for this particular district within Odisha, so that is Ganjam district, and this guardian minister will actually looks after everything in the district with respect to social development, economic development, infrastructure development. So everything is overseen by this guardian minister, and that is the concept of guardian minister. And this position of guardian minister is typically held by senior politician from the ruling party. So who is this senior politician from the ruling party, and this position is being held by that particular person who actually acts as a liaison or a coordinating link between the state government and the district administration. So thereby, so the overall objective of developing the district, the social development, economic development, and even the infrastructure development of that particular district by providing necessary resources and at the same time support to meet its developmental goals. So those ministers are known as the guardian ministers. And apart from that, this particular minister may serve as the guardian minister for multiple districts also. So not just for single district, but he can also serve as a guardian minister for multiple districts, looking after everything closely and suggesting recommendations for the development of the district. So this post of guardian minister was introduced to bring to the attention the implementation of government policies, reforms, public welfare schemes in assigned districts within the state. So there are certain districts which are considered as the backward districts, right? So the guardian minister essentially takes care of these backward districts. Now there are certain roles and responsibilities for this guardian minister. So what are those roles? So he actually oversees the execution of various state government schemes and programs. So now state governments and central governments have actually come up with number of programs. So the guardian minister essentially takes care of the implementation and execution of these central and state government programs in the district, and at the same time he also ensures the smooth functioning of the district administration, because he is actually a linchpin between the district administration and the central government, state government. So therefore he ensures the smooth functioning of the district administration. And apart from that, every district has a district planning and development committee. Now this district planning and development committee plays a very important role in allocating resources for the development of the district, and at the same time regularly reviewing the government programs and policies. And therefore this guardian minister is the ex officio chairman of the district planning and development committee. And in fact, this guardian minister is also responsible for the implementation of developmental and infrastructure schemes in each districts. And apart from that, he is the final decision making authority on matters related to the expenditure out of the district planning and development committee's funds. So these are essential roles and responsibilities of the guardian minister. And the concept of guardian minister is actually a welcome initiative, because this guardian minister essentially looks after the developmental needs of those districts, and thereby rapidly increasing or rapidly further promoting the development in those backward districts. Now the next very important issue is Aadhaar based payment system. And this Aadhaar based payment system is regularly in news, because recently the union government planned to make this Aadhaar based payment system mandatory for the Mahatma Gandhi National Rural Employment Guarantee Act workers. So they have protested against implementation of this Aadhaar based payment system for these Manrega workers as well. Now it is also very important, so we'll try to understand briefly what exactly this Aadhaar based payment system. Now this is a type of payment system and which is based on a unique identification number. Okay, so it actually based on a unique identification number, and that allows the Aadhaar card holders to seamlessly make financial transactions through Aadhaar based authentication. For example, now if you have this Aadhaar card with you, and if you have this Aadhaar card with you, and your Aadhaar card is actually linked with your bank account. Okay, so if it is linked with your bank account and you have Aadhaar card, what happens here is that you don't require any bank account number or IFSC code. It doesn't require any OTPs. So there is no need for all those things, and you can directly make payments using this Aadhaar number through this Aadhaar based payment system. That is, seamlessly make a financial transactions through Aadhaar based authentication. And in fact it is a bank led model, so which actually allows the online interoperable financial transactions at point of sale machines, at micro ATMs, through the business correspondents and the bank mitras, or of any bank using this Aadhaar based authentication. Okay, for example, now if you want to make a transaction to your friend, so maybe you require the financial details of your friend. You require, if it is through UPI, then you must require the UPI address, all those things. But on the other hand, the Aadhaar based payment system doesn't require all those details. You should have an Aadhaar card, and this Aadhaar card number should be linked with your bank account. So that's enough to transfer or make payments seamlessly. So this Aadhaar based payment system removes the need for OTPs. OTPs are not required, bank account details not required, and other financial details are also not required. So therefore it essentially allows fund transfers using the bank name, Aadhaar number and fingerprint, which is captured during the Aadhaar enrollment, and that is how the Aadhaar based payment system actually works. However, neither unique identification of India, so that is the authority which actually responsible for maintaining the Aadhaar database, and the National Payments Corporation of India, so that is another agency which actually looks after the unified payment interface and other payment related matters, with respect to the digital payments mentions clearly that the Aadhaar based payment system is enabled by default. So we don't know whether Aadhaar based payment system is enabled by default or not. Now other important scheme is Shreya scheme. So this Shreya scheme is an umbrella scheme by Ministry of Social Justice and Empowerment, and this particular ministry has launched this Shreya scheme. Now Shreyas is actually a program basket, and that actually comprising the initiatives of 3 different ministries. Now what are those ministries? Central Education, Ministry of Skill Development and Entrepreneurship, and then Ministry of Labor and Employment. So these 3 ministries schemes are actually combined together and then provided to the weaker sections under this Shreya scheme. And please remember that which ministry is the head ministry of this particular scheme, and then it combines or comprises which of the following ministries. So you just have to remember these ministries. Now what are the schemes which are actually combined under this Shreya's program? So they include National Apprenticeship Promotion Scheme and National Career Service as well. So what is the objective of this Shreya scheme? So the objective is empowering OBCs and economically backward classes students educationally by awarding them fellowships, so that is financial assistance for obtaining quality higher education, and interest subsidy on the education loan for overseas studies. Okay, so this is the objective of the program, Shreya's program. And then AINA dashboard. So this AINA dashboard was launched by Ministry of Housing and Urban Affairs. Okay, so this was launched by the Ministry of Housing and Urban Affairs, AINA dashboard for cities. And in fact, the overall objective of this AINA dashboard is a portal which compares similarly placed urban local bodies and promoting the peer learning among these urban local bodies. Okay, so it identifies similar urban local bodies and then it promotes a peer learning. So what we can learn from those similarly placed urban local bodies, and how can we improve the governance structure? How can we improve the infrastructure in those urban local bodies? And that is AINA dashboard of Ministry of Housing and Urban Affairs. Now what are the objectives of this particular AINA dashboard? So it provides information, right? So to provide information on status, progress of these urban local bodies based on 5 different thematic areas. And secondly, it provides inspiration by healthy competition between 2 similarly placed urban local bodies to regularly monitor their performance and learn by comparing it with the others as well. So that is what is AINA dashboard. And then so we'll briefly understand about this aspirational districts program. So we knew that the Niti Aayog actually launched this aspirational districts program for the backward districts across the country, and it essentially focuses on developing infrastructure in those backward districts, education, healthcare, drinking water, all those things are being focused under the aspirational district program, which was launched by Niti Aayog. On a similar lines, we have also launched aspirational blocks program. So this aspirational blocks program is on similar lines of this aspirational districts program. So this was launched in 2018 and it also covers around 112 districts across the country. So this aspirational district program covers 112 districts across the country, and this new program is aimed at improving the performance of different blocks. For example, now the decentralization generally follows in this way: district, blocks, and then villages. Now this aspirational blocks program essentially focuses on these blocks. So this particular program aimed at improving the performance of those blocks which actually lag behind on various developmental parameters, and this will enable a holistic development in those areas that require added assistance from the government. And in fact, the aspirational blocks program will cover around 500 districts across 31 states and union territories in its initial phase. Now, what is this aspirational district program? As I have already told you that this aspirational district program was launched in 2018 by Niti Aayog, and it aims at transforming districts that have shown a relatively less progress in key social indicators. Now, what are those key social indicators? The focus of the aspirational district program on 6 different areas. So majority focus will be placed on education, and then healthcare nutrition, followed by education and healthcare. Agriculture irrigation would be the third priority area, and then basic infrastructure in those aspirational districts would be a next priority area, followed by skill development and financial improvement or inclusion. So these are the focus areas or the priority areas under the aspirational districts program. Now, as of now, so 117 districts are identified in a transparent manner. Okay, so there are different districts: 27 Niti districts, 55 central ministry districts, and 35 left-wing extremism districts by the Ministry of Home Affairs. So these are all the aspirational districts across different regions of the country. Now, the majority of the concentration of this aspirational districts is located in this belt, and this is the region which is considered as backward, socially, economically and infrastructurally backward region, and at the same time this is also the region with the higher presence of left-wing extremism, and because of that reason the aspirational district program was launched by the union government or Niti Aayog. Okay, so that's all in this lecture, and thank you so much being here. We'll also continue this series, and we'll also discuss most important current affairs, okay, over a period of time. And thank you so much. Please subscribe to our YouTube channel and also hit the like button. Thank you.